The decision by a grand jury not to indict in the death of Eric Garner is a miscarriage of justice. It's an outrage. It's a disgrace. It's a blow to our democracy. And it should shock the conscience of every single American who cares about justice and fair play.
We have reached yet another instance where seeking to play attorney is one of the more dangerous things we who cover the news can do, because all too often what we saw and then think we know can be turned into the stuff of riots and a greater level of misunderstanding. But it is fair to add that what we all saw in the Eric Garner case seems very cut and dried. Seems. So what are the facts? Let us seek them out. Welcome to MidPoint, former prosecutor, former assistant district attorney in Bronx County, now part of the masthead at Hochheiser and Hochheiser in Manhattan. Daniel Hochheiser joins us. Daniel, thanks so much for being here today.
Thanks for having me, Ed.
And your initial reaction when you saw the video, did you, like the rest of us, believe this was a cut and dried case?
No, I didn't think it was a cut and dried case because I have lots of experience with police cases, and I knew there would be testimony from the officer in the grand jury trying to explain away his conduct. I am very disturbed by the video and by the process by which the grand jury reached a no indictment. The public is rightly flabbergasted by this decision because the grand jury process is secret and they can't assess the testimony of Officer Daniel Pantaleo or see any of the evidence in the grand jury. So how is the public supposed to accept, just on faith, this decision, which seems to be very contrary to the clear evidence on the videotape?
Okay, I'll play devil's advocate here. Is it not necessary for a grand jury to have that complete silence, if you will, and that complete privacy, because this way nothing from the outside gets inside the courtroom normally, as it would be, to perhaps infect the proceedings or to make people think otherwise? It keeps it quiet and keeps it legal. Just a guess.
Well, it's not only that, it's part of our Constitution. So you have a right to be indicted by a grand jury if you're going to be charged with a felony in this country. So, you know, it is a constitutional rule. It may be something we want to revisit because these secret proceedings in police homicide cases don't seem to work in terms of the public being able to digest and understand what is happening in their criminal justice system.
Dan, you as a former prosecutor then answer this, if you will, because we've heard this both in Ferguson and now here in Staten Island, that the prosecutors in the grand jury perhaps dissuaded the grand jurors from making a certain decision, that they molded them to exactly what they wanted, and because the prosecutors have to work every single day with the police, that they don't want to make this stick and that they are the ones who are the problem here, not necessarily the grand jurors.
Ed, the answer is the appointment of special prosecutors in these police homicide cases. That's clear to me after Ferguson and after Garner and Staten Island. You have these relationships, as you pointed out, where the DA's office relies on the local police departments as witnesses to make their cases each and every day, day in, day out. It's too close a relationship. Even if Dan Donovan in Staten Island and McCullough in Ferguson are doing exactly the right things in the grand jury, and at least in the Ferguson situation, that's arguable. You know, it's just there's an appearance. And if you had a special prosecutor, somebody who's from another state, another jurisdiction, whose credentials are beyond reproach, I think the public might be able to swallow a grand jury decision like we saw in Staten Island yesterday.
Any doubt in your mind, though, that it does go on, that some prosecutors will indeed move things to their own agenda because they want to make sure to keep the police happy in their own community?
Well, I'll just talk about the Ferguson case specifically because I've read some of the transcripts of those grand jury proceedings. I haven't read all of them, but I've read some of them, and it was clear to me that, even though I did agree with the ultimate result, that the district attorney had a certain view of the evidence and questioned Officer Wilson and other witnesses in a way to move the case in a certain direction. And that's what prosecutors do in every grand jury. They have a certain view of the case. They're human beings. They have biases. They have opinions. And they craft the evidence to reach the result that they think is just.
All right. Now, if you would stand by for just a couple of minutes, break. Much more to cover with Attorney Daniel Hochheiser, beginning with the Cleveland case of a 12-year-old being shot and killed while carrying a toy gun. And now the Justice Department is getting ready to make a statement on that case. We're right back.